Good evening to all of you. We'll be waiting for quite some time for maybe reasonable number to join before we start. So as I indicated in our invitation that we would like to first do some general revision of selected aspects of contract. So tonight, I want us to fully exhaust everything which needs to be known as far as terms of contract are concerned so that we don't ever have to come back to this area. So this is what I propose to do. As I keep telling you, we come to this class on assumption that you have done the substantive learning already. And our task is to help you to understand or clarify certain things that you may be lacking understanding. So I'm going to quickly summarize the law without going through elaborate points, which I will have already done if I'm just treating it as a topic to people who have not learned it before. I'll just do this in a few minutes and then we take questions. So as we take the questions, I think that will pave way for us to do more discussion. So before we come back to the questions, which we'll be looking at the one essay type question, one problem-based question, and then a number of multiple choice question. So the idea is that as we go through some of the questions, that should enable us to resolve any doubts or ambiguities or maybe some misapprehension which we may have as far as some of these principles are concerned. So before we continue with the questions, as I said, let me use some few minutes to quickly summarize what we need to remember as far as terms of contract is concerned. And I have a number of slides on this. I could later push them on the platform for you if you still care for them. But I thought that at this stage, you have all the materials that you need to have preparation. So having said that, when we talk about terms of contract, first of all, we have to appreciate that it's a very important aspect of our law of contracts. And what are they? What are terms? Terms, also known as the content of contract, basically refer to what the parties have agreed upon. Their respective duties under the contract, the obligation under the contract, their rights. These are what we call terms of contract. So as far as terms are concerned, we need to appreciate when a contract is being made, a number of discussions or statements are made by the parties to each other. But the big question is, are all these statements meant to form part of the terms of the contract? The answer is no. So we need to find out which of the statements made at the negotiation stage form part of the contract and which of them do not form part of the contract. Ones which form part of the contract are certainly called terms or terms of the contract. And they are so called because they create obligation, they create duties. If they are not carried out, it will provoke legal consequences. And those legal consequences are simply that there will be a breach of contract. And while there's a breach of contract, then the remedies for breach of contract that you have seen previously will kick in, or seen for remedies where applicable, or some equitable remedies for specific performance or injunction, as the case will be. On the other hand, where we say that the particular term, sorry, not the term, the particular statement made at the negotiation stage or the pre-contractual stage is not a term, then it is a representation. A representation is a statement of fact meant to induce or persuade another person to enter into a contract. And what that means is that should there be non-compliance or should it turn out to be untrue, should it turn out to be false, the legal consequences it provokes is simply that the affected party can sue for misrepresentation or can bring an action in the tort of deceit. So these are some of the differences that we appreciate. Then we come to the question, how do we know which of the statements are a term and which of the statements are representation? I'm talking about the statement made at the pre-contractual stage or the negotiation stage. Now, usually, if you look at the case law and the literature, the court will pay attention to first the importance of the statement. And by this, what it means is that the more important the statement, the more likely the court will say that that statement was meant to form part of the contract, for that matter, a term. And then the vice versa, the less important or unimportant it is, and the court will say that it was probably just a representation. And then there are two, the court will also look at the timing of the making of the statement. If the statement was made closer to the making of the contract, then it raises the high probability that it was meant to form part of the terms of the contract. On the other hand, if the statement was also made long ago, you know, like the case like the Rutledge and McKay, if the statement was made long ago before the contract was concluded, then that statement would not be treated as a term, it would more likely be treated as a representation. Okay, so that is the second point. Then the third point is that the court will look at the level of expertise of the maker of the statement. If the maker of the statement, for example, claims to have expertise or appears to have some expertise, then the statement that he made will not be taken as just ordinary representation. It's more likely to be treated as forming part of the contract, and for that matter, a term. And fourthly, sometimes the court whether after the making of the statement, the transaction is reduced into writing. If a statement has been made and subsequent parties have entered into a written contract, then if a particular statement was not included in that subsequent written, then it was not meant to form part of the terms of the contract, and then the vice versa. So these are some of the things that we have to look at. Now, having known how the court will classify pre-contractual statement or the negotiation stage statement, we also have to understand that terms of contract are two kinds. We have what we call the express terms and we have the implied terms. Express terms simply refers to terms which the parties to the contract have negotiated, agreed upon. So they have addressed their minds with what they want to form part of the contract that we are making. So those are the express terms. And in terms of application or recognition of express terms, we may have to appreciate that contracts are of two kinds. We have like the written contracts and then or contract reduced into writing, and then the oral contract, also known as the parole contract. Now, where the contract is oral, that is parole, meaning that it is not reduced into writing. In trying to find out the terms, in trying to find out what the parties actually agreed upon as constituting the obligation or the duty that they have assumed under the contract. Now, what we do is simply to use objective tests. The objective test, if you remember the case of Smith, Tamplin and James, Raffles, and which has those type of, and then the court will try and find out by the objective tests, having regard to the external appearance, external manifestations of what the party said and did. Those are the things which will guide the court to try and arrive at the terms of the contract, that is express terms. And here we are dealing with an oral contract, we are dealing with a parole contract, a contract not reduced into writing. And that is why the court will have to be guided by the objective test, as it were, to make a determination as to what the parties actually agreed upon. So let's keep that in mind. And again, where the contract is reduced into writing, then identifying the terms is not very difficult. Where the contract is reduced into writing, express terms are recognized by looking at what is contained in the written contracts. And in that respect, the courts emphasize a particular evidential rule, which we call the Parole evidence. The Parole evidence rule. The Parole evidence rule simply means that where the contract has been reduced into writing, then the parties are considered to have actually agreed upon what is contained in the writing, and the parties will not be allowed to go outside what the written contract is saying, and that is the Parole evidence rule. So no extrinsic evidence, no external evidence will be entertained by the court to vary or to change what the written is saying. So that's how the court will go about trying to identify what the terms of the contract are. I'm talking about the express terms, where the contract has actually been written. And as I said again, the court will take the position that what the parties agreed upon is what is contained in the written contract or in the writing. And for that matter, nothing outside of it will be allowed to contradict what the writing is saying. That is why I said that is the essence of what we call like the Parole evidence. And the Parole evidence rule, as you know very well, plethora of cases, Wilson and Brobe, you take our own evidence, you take the evidence act. We have, it has also been codified, or be given a statutory footing. And as a general rule, that as I said, where you have actually reduced the contract into writing, then you will not be allowed to say that something is contained outside the contract. And so many cases, upon an announcement by the Supreme Court, Robe, Section 177 of the Evidence Act of 1975, NRC Decree 323. All these provisions actually enacted or codified the Parole evidence rule. But the Parole evidence rule is not cast in stone, meaning that it is possible for some exceptions to be entertained. For example, if you look at the case law, as well as even the provision of Section 177, for example, you will notice that where the parties, for example, have not reduced the contract fully into writing, then what will happen is that the court will try and take external evidence in order to establish the other part of the contract, which is not actually contained in the writing. As I said, I cannot have like the luxury of time to actually go, details of things. But as we discuss questions and so on, you'll be able to fill in some of the details that we need to be filled in. Because if you have to go according to what is usually done in the classrooms, in the law faculties, we'll just probably do about 3 topics. And that is not what we want to do. We want to be able to quickly revise every aspect which can be examined. So let us proceed in that respect, and let us avoid the the step-by-step nuance or the detailed discussion. Yeah, so that is what we should remember about like the recognition or identification of the express terms in the case of a written contract. As I said again, the court will say that the text is found in the writing. And for that matter, you will not be allowed to bring anything outside that, to change, to add to, or to contradict. And that's what they call like the Parole evidence rule, as it were. And again, apart from express term, we also have what we call like the implied terms. We have the implied terms as well. And by implied terms, we are referring to uh, where the court will try and read some additional terms into what the parties actually agreed upon. And when terms are being implied, the assumption or the understanding is that uh, the courts, and for that matter, the lawmaker, are trying to recognize the unexpressed intention of the parties, that there are some aspects of the intention of the parties which are not really captured by the contract that we have. The intention of the parties to be fully upheld by upholding the contract, you need to read in some additional obligation, some additional duties. So when you are reading in, when you are inferring additional obligations to what the parties have agreed upon, then we say that we have implied terms, and terms may be implied uh, in one of three main ways. They may be implied by statute. In other words, an act of parliament may say that for certain type of contract or certain type of transaction, some obligations or some duties must always be included. And for example, take like the Sale of Goods Act. We know that when it comes to the contract for sale of goods between a buyer of a movable item and a seller, that is a sale of goods contract, there are some obligations which are considered implied in the sense that they are always supposed to be part of the contract, or some of them are also default in the sense that where the parties to the contract do not make provision, then the lawmaker will say that this should be the position. Now, quite apart from terms which are implied by statute, not only the same, you can cite so many examples, including even like the new Lands Act, respect to conveyancing, certain covenants. If you go to the repeal conveyancing decree, when it contract between a purchaser and a vendor of a land or landlord and tenant, certain covenants are quiet enjoyment and so on. Even where the contract does not expressly say so, the statute says that these are also part. So that is also another example of implied, terms implied by statute. And the same thing applies to Labor Act. If you go to the Labor Act, when it comes to the contract between employer and employee, there are certain matters in which the lawmaker say that they should form part of that the contract of employment, so that even if it is silent on there, those provisions of the Labor Act will actually apply. Yeah, so there are a lot of examples of terms implied by statute. What I have mentioned are just some of them, and you could even mention more. Companies Act and so on and so forth. Then we also have terms implied by custom. Terms may be implied by custom. By custom, we're talking about well-established, crystallized practices within certain trade or within certain community, such that those who are actors or those who are stakeholders within that will obviously agree without any protestation that those practices or those customs, those conventions are how things are actually done in a particular field or in that particular yeah. So look at the case of Hutton and Warren. Then look at the Noga cases, how terms are implied, terms which have developed crystallize in certain communities or certain trade or industry. And the court will say that if the transaction between the parties are silent on this, because this is a well-known custom and so on, we are going to actually infer it into the contract which the parties have made. Then the third way in which terms may be implied, that is by the courts. The court may imply terms, and how do the courts imply terms? The court imply terms, first of all, to try to give business efficacy. You know the famous case of the Mukok, to try and give business efficacy. In other words, the court is trying to say that having regard to the express terms of the contract, something is missing, and that which is not there will not allow the express intention of the parties to be fulfilled. And in order for the intention of the parties to be effectuated, not to be defeated, then the court will need to read in some additional obligation. And remember, like the famous Mukok, where the vessel was going to land at someone's, if you like, the port or jetty, and there was confusion as to whether it was a duty of the owner of the facility to warn the owner of the vessel as to whether level, that is the tide, whether it was safe or it was not safe for the vessel to come. And you see how the court said that having regard to the circumstances of the case, contract, and especially the articulated intention of the parties, in order for the intention of the parties not to be defeated, then it was necessary to read in some additional obligations. Yeah, so therefore, we say that terms may also be implied by the court in order to give business efficacy to the contract, to enable the court actually realize the intentions of the parties. Now, quite apart from that, terms may also be implied by the court in order to fill in, if you like, the obvious issue by the court. And by that, the court will say that it is using the position of an official's bystander. In other words, if at the time that the parties are meeting the contract, the particular term which the court is inferring, if their attention have been drawn to it, the court is saying that the parties will have right away nodded in agreement that yes, that particular term was also meant to be paid to the contract. And that is why one of the judges will say that the parties will have just, it's also a part of the terms of the contract. Look at the case of the Liverpool and the Irwin. Yeah, so these are how terms are implied by the court. And again, we also need to appreciate that terms of contract are not of equal importance. Some are more important than others. Just as the animal farm, all animals are equal, but not all. I mean, not all animals are equal. Good. So terms, they are all part of the contract, but some are more important than what? Than others. So relative importance of terms. Traditionally, I mean, until the last almost 50 years, terms were either a condition or a warranty. A condition or warranty. A condition simply means that it is a term or obligation of major importance. And because the obligation of major importance, it goes to the very foundation or the very root of the contract. And what that means is that in the event of a breach of that, the innocent party is entitled to repudiate the contract. Repudiating the contract means that he's entitled to treat the contract as having come to an end, as having been terminated. And for that matter, he can go to court and sue the defaulting party for damages as well. On the other hand, where a term is classified as a warranty, what it means is that it is a term of relatively minor importance. And for that matter, in the event of a breach, the innocent party cannot repudiate the contract, cannot treat the contract as having come to an end. It can only sue for damages. You have to continue and observe the obligations under the contract. Now, so these two classifications were what we have. These two classifications were what we have for a very long time. So as I said, terms were either a condition or warranty. But all this changed, and we got like a hybrid term. You know, in 1962, we got like the hybrid term following the case of Hong Kong Fair against Kawasaki Kazan Kaja, in which English court of appeal said that if you look at certain types of contracts, it is not possible for you to read the contract and what the parties have agreed upon and simply say that this is a condition or that is a warranty. That for some of them, you would need to actually wait for a breach to occur before you can say that this particular term, which has been broken, should be treated as a condition, or this particular term, which has been broken, should rather be treated as a warranty. And for that matter, the court was saying that you need to adopt what we call like the wait and see approach. Wait and see approach simply means that you cannot just look at the contract and say that this is a condition or this is a warranty. Rather, you fold your arms, you wait and see. Wait for a breach to actually occur. And when a breach of the term has actually occurred, you engage in weighing exercise. You try to assess or weigh the impact of the breach on the contract. The impact, if the effect of the breach of that particular term on the rest of the contract is so significant, is so radical, in the sense that it effectively deprives the other party of whatever benefits that is supposed to get under the contract, then you say that that party should treat the breach which has occurred as if it were a condition. And for that matter, giving the remedies for breach of a condition. The court is not saying that it is a condition. The court is saying that it should be allowed to assess remedies which are usually given for a breach of a condition. And on the other hand, where a breach has occurred, you have done the analysis and you come to the conclusion that the effect of the breach is not that huge. And for that matter, the contract can still continue. Then the innocent party will be given the remedies which are usually given for breach of a warranty. Now, the other question may arise. How do we even know whether a term is a condition or warranty? Well, it depends upon the intention of the parties and not the label which the parties have given in the contract. So, for example, if we look at the scale of a schooler against the Wickman machine tools, the court will tell us that the description that the parties have given to the contract is one thing, and what the court will say that particular term is another thing. And what the court will say that particular term is a reflection of the intention of the parties. So if the label which the parties have given is not an accurate reflection of their intention, deciphered by the court, trying to construe what is in the contract, then the label will be put aside, and then the court will rather treat that term as what their determination of the intention of the parties virtually turn out to be. So that is what in that regard. So we have said that quite apart from condition and warranty, we also have a nominate term, also known as intermediate term or hybrid term. And as I said, it's so called because you cannot classify a term as a condition or warranty until there has been an actual breach. When an actual breach has occurred, then you look at the impact or the effect of that breach on that particular contract before you can, innocent parties should get this remedy or should get that. Okay, so that's about that. Now, finally, let's come to what they call the exclusion clauses, exemption clauses, and limitation clauses. And then we will take the questions. By exclusion clauses or exemption clauses, we are referring to a contractual practice, that is a practice in contracting, in which one party will try to get the other to agree that if I am in, either I cannot be held liable, or if I can be held liable, I can be held liable only up to a certain limit, up to a certain quantum of damages and no more. Now, where the particular clause in the contract is saying that the person cannot be held liable at all, we call that exclusion clause or exemption clause. On the other hand, where the clause is saying that the person can be held liable, but only up to a certain limit and not beyond that, then we call that limitation clause. Well, the courts frown upon practices because they undermine, you know, freedom of contract in a sense. Why Olu say that when you are in breach, you cannot be held liable, or you cannot be held liable beyond a certain limit and all that. So that obviously suggests fairness. And for that matter, the court set a very high bar, a very high threshold that before you actually uphold exemption or exclusion clause or limitation clause as a valid, a stringent test should be passed. In other words, it must be demonstrable that that particular term actually forms part of the contract. It forms an integral part of the contract, meaning that the parties might have freely accepted, agreed that it should be part of the contract. So that is one thing. And secondly, even when it is demonstrated to form part of the contract, in the event of a breach, the courts are still very strict. The courts are strict in the sense that the courts would like to find out whether the wording of the clause covers the particular breach event that has occurred. If the court construes the wording of the clause and it does not cover the particular breach event, then you cannot rely on it and escape liability or escape responsibility, as it were. So for that purpose, few principles should be remembered. We have to find out whether the exemption clause that we are dealing with, whether it is in writing requiring the signature of the parties, or it is in writing but does not require the signature of the parties. Where it is in writing requiring the signature of the parties, and the position of the law is that, as a general rule, once you have signed the clause, you have signed the document containing the exemption clause, you are assumed or you are taken, you are deemed to have actually accepted that it forms part of the contract and you are bound by it. So that is one thing that you should know. If you did not read it, it doesn't matter. That is no excuse. Remember the cases of Lestrange and Gracop and all that. But there's an exception where you have signed, but you signed it as a result of a fraud or some deception. Then remember the Curtis Chemical Clean Dyeing Company, the woman with the wedding gown. Yeah. Then the court will say, because you signed as a result of some misrepresentation or as a result of some fraud, you are deceived into signing, you will not be bound by what you have signed. Or you can play what we call the play of a non-ex factum. Non-ex factum means that you are saying that this is not my deed. The document I have signed is radically different from that which I intended to sign. So we keep that in mind. But of course, we have to note that if, for example, you require reading glasses, you didn't have your reading glasses, like I have my reading glasses, and let's assume that I cannot read at all. Without the reading glasses, a document is brought to me, and I sign that particular document, knowing very well that my reading glasses was not with me. I will not be allowed to escape liability. I'll be bound by what I have done. And I hope you remember the case of the Garley and Lay, Sounders. And then again, we also have to remember that where the exemption clause is not the type which requires signature, then the position of the law is that adequate notice should be given. Adequate notice should be given. Now, as I speak to you now, I'm aware that the Law Reform Commission is currently doing a work which is meant to enable Ghana to adopt our own legislation on unfair contracts and also to legislate on some of these exemption clauses. So, assuming whoever will be asked to set the question this year, assuming he is part of the Law Reform Commission or he knows the project going on, it can be an interesting invitation for you to try and discuss maybe the states of the law on maybe either terms of contract or exemption clauses in particular, and make a recommendation for the law reform committee. So I'm not saying there's anything like that coming, but aware of the ongoing project of the Ghana Law Reform Commission, and we learning this topic. I thought that it is proper that I draw your attention to it so that you can also start thinking along that those lines. Yeah. So coming back, where the exemption clause does not require writing, let's say that you go, there's just a, it doesn't require signature, it's in writing, all right, but you don't have to sign it. Then the position of the law is that you must be given adequate notice regarding existence of that exemption clause. So once given adequate notice regarding existence of that exemption clause, you could be bound by it. But the notice should be given before or at the time of making the contract and not after. So that is another thing that we should keep in mind. So remember the famous case of the Ole and the Marble. Just like maybe you are sitting in a hotel and I'm sorry, you go to a hotel. Well, I'm in a hotel, that's how I'm talking like that. You go to like a hotel, for example, where is the contract made? Is at the reception point. So if you come to the hotel room and they have some writings trying to say that they have excluded liability for certain things and all that. Now that per se is not going to be, that per se is not going to bind you because that is, I'm teaching online. Okay. I'm teaching online. All right, bye. Yeah, so that per se is not going to bind you because that is, you became aware of it after the contract has been made at the reception. So that is what we should remember. Now, finally, let's come to interpretation of exemption clause. Let's assume that the court is satisfied that either by signature or by adequate notice, you have reasonable notice, you will be made aware of the exemption clause, or you have accepted to be bound by the exemption clause. A breach of contract. Now, let's suppose that the exemption clause is worded in such a way that its meaning is quite ambiguous. Its meaning is quite big. So where there are more than one meaning of the exemption clause, then the position of the law is that the court will go for that particular meaning, which is more disadvantageous to the person at whose instance the exemption clause was included in the contract. That is what is famously known as the contra proferentum rule. Contra proferentum rule. So contra proferentum simply means that the contract or the clause is interpreted against. So contra means against, and proference, that is the person who proposed or the person who preferred. So if the clause has more than one particular meaning or interpretation, the court will pick the one which is not to the advantage of the one at whose instance it was included, but go for the one to hurt his interest. And that is consistent with the court's, if you like, displeasure with exemption or limitation clause as it were. So these are some of the things that we have to remember. And having said this, we'll be looking at questions pretty soon. Maybe let me take some few questions. Well, if you want to ask a question, you can put up your hand. Otherwise, we discuss the questions that I have here. Okay, so we would like to start, let's say, one essay type question. The one essay type we are looking at is just representative, right? It's just representative in the sense that you want to just get like the sense of how the questions are approached. So we have two. Let's look at the first one before you look at the second one. Maybe you can call this question one, and then call this let me see. Okay. Okay, so let's take question one. Discuss the importance of discuss the means of determining the relative importance of contractual terms, the effects that status has on remedies available, and whether it is appropriate to determine those effects after breach has occurred. So if you take question one, yes, I've seen somebody's hand is up. And John. Yes, Aniaba.
Yes, sir. My question is on the exclusion clauses. I don't know if we are done, but
yes,
we from what we read, we realized that the exclusion clauses from its incorporation, its interpretation, and everything to the the doctrine of fundamental breach, and now there's now from at least from what I'm from Hammond, yes. Now the rule used by judges is the reasonableness, and that one they would consider a host of other one depending on the bargaining powers, whether they insured, whether it's in the commercial settings, among a host. So my question is, when in an exam, when you get a question on exclusion clauses, do you necessarily have to go through the incorporation, interpretation, the things to look out for, like as you just went through. Do I have to state that, okay, before the case of I think photo versus secure something, that is when the first case of reasonableness was used and has been used since. So the question, the question is, when you get a question on exclusion clauses, do you just go straight away and state that this is the law as it is now based on the photo
production?
I think photo production. Yes, do you just go, or you would have to talk about as we talked about, we look at the incorporation, the interpretation, when it was made, and all that, to even talk about the doctrine of fundamental breach.
All right, John, thank you very much for your question. Yeah, thank you very much. That's the kind of thing I want to be hearing. So here, you are giving me evidence that you've done the learning, but you need assistance regarding how to apply the knowledge that you have acquired from learning to answer the question. Good. And that is why we are doing this exercise. Now, first of all, John, it will depend on whether the question that we have is an essay question or whether it is a problem-based question. So that is my first comment. And secondly, if it is an essay question, it will also depend upon the nature of the question. If, for example, the question is saying that, yes, the Ghana Law Reform Commission is or has embarked on a project to legislate on terms of contract or unfair contractual practices or whatever. So as a student of law of contracts, submit a memorandum stating those areas of the law which you think are in need of reform. So let's assume you have like a question like that, okay? Let's assume you have a question like that. What that is asking you to do is first and foremost, demonstrate that you know and understand the current state of the law and you are aware of the problem areas. So in a question like that, it is since you are required to make suggestion on those areas which needs reform, you also need to do a bit of like, if you like, the historical review, just like what you have suggested. So yes, let's say that when it comes to area of interpretation of, let's say, exemption clauses, no doubt there has been significant confusion as far as the law is concerned. Maybe the only rule which is not problematic is the contra parentem. The rule that where you have more than one meaning or interpretation of the particular clause, you go for the clause which is most disadvantageous to the interest of the one at whose instant the clause was included in the contract. That one, for example, is is really beyond dispute. But when it comes to the so-called fundamental, fundamental breach, if you look at the literature, it's generated a lot of confusion until recently the House of Laws will say that there's nothing like that has been a fundamental breach of the contract, and for that matter, everything in the contract does not have to be followed, does not have to be upheld, and it affects everything. No, that we should rather adopt what we call the constructionist approach. The question of just interpreting, the particular term rather than having any predetermined conclusion, as used to be the case with the so-called doctrine of fundamental breach and so on. So, therefore, this is an area where there's a need for, let's say, clarity. So, if you are going to have do not be out of place to, for example, have a specific provision clarifying how, let's say, exemption clauses should be construed or should be interpreted, something like that. So, John, so if it is an essay, that is how you have. On the other hand, if it is a problem based, you don't need to tell us. And I've said it before, and I'll say it again that where, excuse me, that where you are dealing with a problem based question, you are supposed to behave like a hypothetical lawyer, like a lawyer. And when a lawyer is given a problem by the client, the lawyer is supposed to apply the law as it is now to try and uh, advise the client. You're not supposed to tell the client what the law used to be and how it has come to be this and how it is likely to move in this particular direction in the future. No, that is not what you do when you are solving problem-based question. Problem-based question, you are supposed to apply the law as it is to the problem. Just as somebody will say that, no, if you go to the one of the three programs on the TV or radio, that the Papa lawyer, Emrano is saying, for that person, what is interested in is that as far as this problem is concerned, what does the law say? He's not interested in what the law used to be or what the problem or what the law will be like. So what Emrano is saying, what is the position of the law as far as my problem is concerned? So that is we use when it comes to problem-based questions. So we have to appreciate that. Unless in the problem-based question, the examiner is trying to introduce another layer of complexity and say that maybe after saying that advise the parties, it has maybe like a tag on or a follow-up question saying that assuming the law, assuming this problem has happened in this particular year or this, has done this, then you notice that the examiner is trying to ask you to do some other particular exercise. Otherwise, in the general scheme of things, when you have a problem-based question, you must apply only the current state of the law and not the historical aspect or not the projected developments of the law. Yeah, so John, I don't know if that assists. Oh, okay. Law reform. Okay, there's a document which I will make available to you. The law reform, like. Okay, so coming back to our question, discuss the means of determining relative importance of contractual terms, the effects that status has on remedies available, how it is appropriate to determine those effects after breach has occurred. Now, if you look at a question like this, it's pretty straightforward in terms of what we are being invited to do. I don't think any of us find any ambiguity or regarding the import of the question. It's pretty straightforward in terms of what we are invited to do. Is there anybody here who is not clear regarding what the question is inviting us to do? Is there anybody who is not clear in terms of the import of the question? Yeah, so I think it's quite clear what I'm required to do. And if we look at it, we are required to do about three things, isn't it? One question, but you notice that three things are embedded. So first, we are asked to discuss the means of determining relative important contractual terms. how do you determine it? And then we are asked to discuss the effects that status has on remedies available. What is the effect of the status of maybe saying that a particular contractual term is this? What is the effect of that on remedies which are available for such term? And thirdly, whether it is appropriate to determine those effects after breach has. Okay. So this is what is required of us, and I don't know if anybody will volunteer to lead us to discuss question 1. I want the one person to attempt, and then we comment on the person's response. Yeah, who would like to attempt leading in responding to question 1? Yes, anybody? Oh, why? You want to tell me you know me following? Who volunteer? Okay, Bright. Good. Right, Barton, please go ahead.
Doc, it's not really about volunteering to answer the question. I don't really understand the demand of the question, especially the second part of it. The effect that this statute or status has on remedies.
That's status.
Statute or status?
No,
status.
No, status.
Okay.
Yes.
Okay. So I was confused about that. So that's why I raised my hand. Thank you very much.
So any volunteer, you want one person to lead us to discuss question 1? Any volunteer? Oh, last year I was getting a lot of people who were very eager to be speaking. This year, people, you don't like talking. Why? Still not getting anybody. Okay. Yes, Francis. Francis,
Yes, sir. Good evening, sir.
Good evening, Francis.
Sir, thank you very much for the explanations. But honestly, the question is not very clear to me. If it were to be an exam situation, I would find it a bit difficult how to approach it. So,
increase the font size. Increase the font size.
Sir, I'm not talking about its eligibility as in reading it, the comprehension of the demand of the question and the approach of it.
Right.
I'll be grateful if you could give us a little bit of illumination to it.
Then I'll comment on it. Oh, thank you, Francis. So I saw one lady, so Sanam, and then Charles. No, it's a Charles. We have a Charles. Okay. Charles Johnson. Charles, you have the floor. Go ahead.
Okay. So, sir, good evening. I was just trying to understand, first of all, the contractual terms we need to come to clear understanding as to what goes into contractual terms. So I was just thinking, is it probably the duration of the contract? Are you looking at probably the payment terms? If there are waivers, is it what goes into the real contract conversation? So before we can attempt to even give a format as to how the question should be answered, I am thinking we need to come to clear understanding as to what goes into contractual terms. So before we can make that attempt, I want to ask that what really goes into the contractual terms before probably we can attempt to answer the question. That's my submission.
Charles, thank you. Yes, Senam. After Senam, we come to Augustine. Senam. Oh, she's gone.
Okay.
Yeah, Senam.
Okay, so I would approach this question by first defining what a term of a contract is. And by a term of a contract, I would say is the promises, statements, or prepositions that details the rights and obligations arising from a particular contract. So finding what a term of a contract is, I would now come and look at the types of terms, which we just spoke about, the conditions, the warranty, then the innominate. And then with the conditions, we all know that they are mental terms of a contract that goes into the root of the contract, and a breach of it would afford the innocent party to consider the contract as being violated and also sue for damages. And with warranties, they are just considered as the subsidiary terms. They don't really go into the root of the contract, and a breach of it will only afford the innocent party damages and not rescind. So I'll look at the cases with regards to conditions, cases with regards to warranties. Then I come and look at the innominate terms. You just explained a while ago that for them, you wait for a breach to occasion before the court, considering the surrounding circumstances, would decide if it is a warranty, it's a condition. And then, what else do I even look at? I think basically that's how I'm going to approach it. And yes, so that's it.
All right, Sanam, you've done something very good, but you've not finished. You agree you haven't finished. Are you there? Oh, she's gone. Okay. I think there's let's take Augustine. After Augustine, we take Bex and then Charles again.
I think I'll follow after Seninyam. I think I'll follow after Seninyam, where we talk about the terms of a contract, whereby contractual terms allows us to know the role and duties parties play in a contract. We get to see the responsibilities of a party within the terms available within the contract. So in a contract, it might be clearly stated out within the contract, or it might be implied either by statute. So within the contractual terms, there are three things we tend to look for. We tend to look for the warranties, we tend to look for the conditions, and we can have the innominate term. Now, the effect that status has on the remedy available is that when a condition is broken, when a condition of a term is broken, the contract tends to be rescinded. So where Joe goes to has a contract with Grace, telling Grace that he needs to buy a suitcase which is wrapped red so that he can give it as a gift to his friend on his wedding day, which is on 8th December 2021. And Grace fails to give Joe the suitcase before the said date, but gives it after. Just for the fact that she has given it after the said date, she failed to give it the suitcase before the said date. The contract has been terminated. She has failed to fulfill a specific condition within the contract. So when a contract is rescinded, when a conditional term within a contract is not followed by either of the parties, the contract gets rescinded and the affected party or the aggrieved party gets to be entitled to damages. And unlike conditions, when it comes to warranties, when a term which is regarded as a warranty within a contract is breached, it doesn't actually get rescinded, though, because it does not play a huge factor within the contract, making it, that when it's breached, the contract cannot go on. So depending on the terms within a contract, we get to know the remedies available when either of the terms are broken. Then for the third one, I do not know what to say next for the third one.
Augustine, referred to. Let me take a few more people, then I'll comment. I think some people hands were up, but they've removed the hand. Okay, so let's go Sebunsu. Someone Sebunsu. Yeah, Samuel.
Okay, so good evening. I think I am just adding. So the first part discuss the means of relative importance. I don't know whether the question is trying to demand from us what the court will look before they will say something is a term. So if I understand very well, it means that the court will say that it is a term, but not a representation. And you just that the court will look at whether the contract is written or the relative importance, and whether that
I think Samuel's network
statement was made at the time of this implementation. So these are some of the factors that the court will look at to determine the.
Okay, Samuel, your network is not good, so you can use the chat to write what you wanted to say. Then I will look at it and comment on it. Okay. So let me take David and take Andrews. David.
Okay, so I think my colleagues have spoken at length. My net is not, okay, let me just go ahead. So my colleagues I agree with my colleagues on the issue of determining relative, I think they've spoken about the terms. They've also spoken about the effects, the effects that status has on remedies. That is either there's going to be a repudiation or only damages, because if there's a breach of a condition, it will warrant that there would be a repudiation and also damages. But if it's only warranted, then to be only damages, you are not allowed to, to repudiate the entire contract. But then I'm looking at the red one because it seems to be very loaded and complicated, but this is how I understand it, that the question is asking that should we even determine whether there should be a repudiation or or damages? Should we, the effect that will come from someone not interpreting the terms well, and the matter has come to court. So the last question is more or less on the court, how they would, whether it's appropriate that they should read meanings into the term. And then I'm saying that, I'll answer it by looking at, the ways the court determine the appropriate means the court used to determine the appropriate effect that should be given to a contract. And then the court will look at, is there an issue of non-effectum where, let's say you are an illiterate and you have been for example, you are an illiterate and you have been misled into signing a contract you didn't really even understand. So non-effectum will come in the court to consider it. The court will look at contra preferentum rule, that if the one bringing the matter to the court, okay, he would look at the terms that are available, and whether a term there can even be used, let's say an exemption clause there can be used against that person, because and then the court will look at, was there even adequate notice? So if there is not enough adequate notice, why are you now using an inadequate notice against the person to say that there is no contract? So I will look at these three. That's what to look at. That's how I understand the last question. Thank you.
Okay, thank you very much. Yeah, Andrews,
So good evening. It seems you are trying to answer the question or giving us points to consider in the answer of the question. Basically, what I see this question to be about, especially with the first point, that is the means of determining the relative importance of contractual terms, is basically about the express terms of the contract. If the question is, if I understand the question well, the contract, that is that's got to do with the condition, warranty, and in nominee terms. And I think my lady who spoke before spoke about condition. That is one of the most important term of the contract, because of Prasad and Spears as the case in there. Then look at warranty, which is Bettini versus Guy, to explain that term. And then you go to innominate, which will to explain the first point. Now, the second point, the effect that status has on remedies available. I think looking at that question, in the situation where there is a breach of the contract, what remedies are available for the person? And my brother who spoke, who just spoke lengthy on that. Whether you the remedies available to a person who has had a contract breached, whether you continue the contract or whether you rescind the contract, that will determine that will be determined upon the person's decision. But whether it is appropriate to determine those effects after the breach has occurred, I think that one is an implied term in the contract, where the court will have to take into consideration the courts take by custom and statute. I think putting all these three together, probably we'll be able to look at the question very well and then answer it probably. That's what I think, sir.
Yeah, Nana Jamfi, you can speak now. Sorry, I had muted myself.
So I think enough has been said about the first part of the question. And so I will just look at the effect that status has on remedies available. Now, if that one will depend on the commercial standing of the parties and the quality of bargaining. So if the parties are of equal commercial standing, for instance, in the interest of certainty and consistency, interpret the terms more quickly. That will ensure that there's certainty between the parties. And then if you look at the of a condition and then a warranty should be used. And then the court also look at the cost of dealing between the parties. So all of these comes back to the status aspect of the question. So I think that's what I have to say over here.
All right, thank you very much, Anna Jamfi. I think before my line went off, there's another hand up. So yeah, soon, Pieter, please, let's hear you. Then I'll comment on it.
Thank you very much, sir. I think the first part, my colleagues have spoken extensively on it. So the second part of the question is to determine the effects of the terms. And when they talk about, and the second part gives us throws light on which particular term it wants us to talk about. Because it says that after the breach has occurred, and in your explanation, you said that innominate terms are what is looked after the breach has occurred. So in my understanding, I think that after talking about the various conditions, warranties, and innominate terms, you now come and look at innominate terms in particular and see, is it right that the court, after a breach has occurred, before they now intervene to determine whether it is a condition or warranty? And I would then go on to say that, no, I don't support innominate approach because the breach may have been occurred already. The steps that could have been taken to prevent it from getting to that point, then it should have been taken before waiting for the contract for the breach to occur before the court looks at it. I consider the last part, that they're asking us to look at the effects of innominate and whether innominate terms, whether right or wrong. Thank you.
All right, thank you very much. I think a good number of you have made some useful points. Yeah, so, but I think there were one or two contributions to, if your examiners were marking this type of exams, I'm sure I think about two contributors, you introduce a lot of extraneous, like not really necessary material. And some of you also reinterpreted the question to let to deviate, because some of you were talking about exclusion clauses and exemption clauses. Clearly, this question has got nothing to do with exclusion clauses or exemption clauses. So that is what we should keep in mind. It's a very straightforward question. And that is why I've said that a good answer will attempt to canvas these points in using a proper structure of coherence and effective communication. So you let us understand what some of you say contractual terms. When we say what is it, we've explained that already. And some of you have also defined it neatly, which is good. Then you is talking about discuss the means of determining relative importance of contractual terms. So before you talk about the means of making the determination, it will not be out of place for you to tell us briefly about relative importance of terms. What is the relative importance of terms? What are they? So by relative importance of terms, we are talking about the fact that terms in a contract are not of the same value. Some are more important than others. So how do you know that? Because when they are breached, they result in different degree of consequences. And that is why I say that some are more important than others. So some, as you have rightly stated by some of the contributors, some of the terms really go to the very root of foundation, and we say that is a condition, and when it is a breach, we know the consequences. The ones which do not go to the very roots of relatively less important, say their warranty. And then recently, post-1962, in the Hong Kong Fair case, we get what we call the innominate, what they call like the innominate term, or what we call the intermediate term, as it were. So after that, you have to move to tell us about the means, because the question said the means of determining the relative importance. So in other words, how do you go about determining the relative importance? From the contributors so far, I did not get any very useful contribution with respect to the third aspect. So for me, the means of determining the relative importance, because the question that discuss the means, but what way, what strategy, what technique, how do we determine the relative importance of contractual terms? Mainly, intention of the parties. Intention of the parties. And that is why I said that the cases like Wakeman and then the Schuler, Schuler machine and all that, that is important. You need to talk about that. So if you don't talk about the intention of the parties, I don't think you've done justice to the question. And by the intention of the parties, especially, if you remember, talking about the traditional categorization of condition versus warranty. And we make the point that where the parties have used the wrong description, as we saw in the case of a Schooler against the Wakeman machine, 2 sales, and as well as the Ghanaian case, which I cited for you, CAB, the SVB case, you will notice that ultimately it is what the true intention of the parties are, which the court would actually give effect to, and not what the labels that they have used. So the intention is important. Then, apart from the traditional categorization as whether convention as a condition or warranty, another means of determining the relative importance, what we call like the impact of breach. So impact of breach, and that is, or what we call the wait and see. That's why I said that for some terms, their relative importance cannot be determined before a breach has occurred. And you will need to actually wait for there to be an actual breach. When there's an actual breach, then you will be able to determine how severe was the breach. If the breach was so severe that it virtually empties or undermines the rights of the innocent party under the contract, as happened or as was contended, of course, unsuccessfully in the Hong Kong Fair case, then you will see that the innocent party should be given remedies, which are usually given for breach of a condition. On the other hand, if the breach is not that severe, there's a breach, all right, but it's not severe, it's inconsequential, then you will say that the innocent parties should be given remedies, which are usually given for a breach of a warranty. Yeah, so then the other aspect of the question said that the effect that status has on remedies available. So effect of status of terms of terms on remedies. So if you classify as a condition, that status, has it got any effect on the remedies that may be available? Yes. If it is a condition and there's a breach, the remedy available is that yes, you have right of repudiation, and then you also have the right to sue for damages for breach of contract. And of course, with respect to warranty too, we know that the remedy will be only damages. You cannot sue for repudiation. And then if it's a nominate, then the remedy is, depending upon the severity of the breach, you may get remediation and damages, or you may get only damages. And finally, the last aspect of the question, and that aspect was not also addressed by most of you. I think only one person attempted to speak to that, whether it is appropriate to determine those effects after breach has occurred. Now, that aspect of the question is a very noble invitation to us to explore the merits and demerits of innominate term or intermediate term, because that is what the last bit of the question, that's what it implies, whether it is appropriate to determine those effects after breach has occurred. Now, if it's only innominate term where we talk about determining the effects when a breach has occurred, for condition and warranty, we can tell the effect before actual breach has occurred. So that is why I'm saying that it will be useful to explore or discuss the merits and demerits of impact of breach or wait and see approach, which is used in the case of innominate or intermediate term. So in a nutshell, these are the points we are supposed to have canvassed in order to do proper justice to the question. I think somebody has a question. What is it? Okay, yeah, so Zoril, yeah, Zoril, that is right. Zoril, that absolutely right. Okay, yeah, I think that Zoril, that's right. What you put in the chat, yeah, that's absolutely right. Yes. Any question or comments before we move on? We're not coming back to terms again. So after tonight, as far as my classes are concerned with you, anything contra will have nothing to do with terms. So we go to question 4 and then we go to the problem. Yes, let's do. Let's do. Yeah, let's have you. Let's have you. Yes, go ahead. Oh, we lost Alex. Okay, that's fine. Okay, so let's take question 4. Or no, what I call the 4 question 2, but the implied terms give effect to the reasonable expectation of the parties. Discuss the veracity of this statement. Sabio, I'm teaching online. So yeah. Implied terms give effect to the reasonable expectation of the parties. Discuss the veracity of this statement. Yeah, so that's another question for us, and I would like you to try your hands on. Who would like to lead us in discussion of the question? Yes. Any volunteer? I'm talking about the question 4. Let me increase the question 4. Yes, any volunteer? Who would like to try? Okay, so Prince Nketia first, followed by Francis. So Prince.
Okay, sir. So first, in attempting question 4 under implied terms, I will first define terms generally and also define implied terms. And also define under implied terms, there are 3 concepts which will lead to the conclusiveness of the fact that is being presented, so that the parties at the end of the day would justice will be served. So under implied terms, there are customs, and also the court. There is one that is being implied by the court and also by the statute. So generally, under implied terms, these are the 3 concepts under it. And under the customs, it deals with general practices that involves trade, in which the parties, in which it is common among trade, and also the court is one which the court will presume, and also it must be obvious to the parties in their dealings, and also by statute, the one that implied term, the one that is implied by a statute in force. So per the question, it says that implied term gives effect to reasonable expectations of the party. My answer is straight no, because implied term is something that when let's say a particular fact is brought before a court, there are the court will also exercise its discretion. So implied terms will not necessarily give effect. Implied term does not give effect to the reasonable expectation of the party, because it is not an express term stated in the contract or the agreement, but it is something that the conduct of the party, we presume, we conclude that it forms part of the contract. So my position would be that it does not give effect to the reasonable expectation of the party, in that what the parties are concluding, or the subject matter of the contract, there must be an express clause. The content of the contract must be expressly stated. And if it is expressly stated, then we can say that it gives effect to the reasonable expectations of the party based on what the input of the contract. So since reasonable implied terms, the court will also exercise its discretion, and parties cannot rely on the fact that it is by customs, or that when it comes to the one enforced by the court will rule in their favor, because the courts do exercise discretion. So that's my take on that.
All right, Prince, I've noted. I will give comments on you on I have taken more. So Abina Otu. Abina.
Hello, Dr. Apa.
Yes.
Okay, thank you. So firstly, my answer plan will basically be that I will define what terms are and how they can be gleaned from the express writings of the parties, and also how they can also be through oral contracts. But however, there may be instances where the court will imply certain terms, mainly to give business efficacy. So there are 3 instances the court will do so. Firstly, terms implied by the court, terms implied by custom, and terms implied by statute. So in respect of terms implied by the court, these will be terms that the courts deem necessary for business efficacy. That is so that the contract can work. That means that the court does not, out of its own discretion, impute terms that it thinks are rights for the parties, but terms that are indispensable to the contract. And that's what happened in the leading case of Moorcock, where it had to do with offloading vessels. The parties did not include a term that the ground for offloading the vessel would be in good shape or good condition. However, that's what happened, and it ended up destroying some of the vessels. In that instance, the court had to decide whether it was important to impute the term that the ground for offloading the shipment would be of good shape. And then the court held that it's important to hold that such an expression is a term because for the business transaction to be effective, there has to be the safe loading of those goods. So where the parties probably forget to include such a term, and it's important to sustain the mutual agreement between the parties, then the court will hold that it's a term. Secondly, it may be implied by custom. So this is instances where there are similar practices that there are similar contracts to the contract in question or in contention. In this particular instance, let's say it has to do with how parties in an area or parties who undertake wholesale agreement typically contract. So they might do so and have certain negotiations in respect of price, installment payment, delivery of goods, etc. So when it's a course of dealings and the parties do not necessarily include it within the contract. However, there is a general practice that is well known by most people who engage in such similar transactions. Then the court will imply that such an expression is a term. The last one I'd mention is the one implied by statute. So there are specific statutes that determine how specific contracts must be carried out. So for example, the Sale of Goods Act and then the Hire Purchase Act that governs specific type of contracts. So in this instance, even if the statutes into their agreement, the court will still impute such terms there by operation of law. So it's generally true that the party, like the courts, may impute certain terms under these three conditions.
Okay, thank you very much, Abina. Thank you very much. Yeah. Let me take Olivia and then I will comment on it and then we move on. Olivia Doe.
Thank you so much, Doc. I think Abina has done justice to the question. The only thing I would add to what Abina said was that under the terms implied by the court, normally the court looks at the intentions of the parties at the time of contracting. So they would look at the intentions of the parties at the time they were contracting to make, a decision on whatever issue they have brought before the court. So that is what I want to add to what Abina said. Thank you.
Okay, thank you very much. I think a good number of you, including the last two speakers, actually responded to the question very well. And the examiners, they often talk about like a strong response and a weak response. So some of the contributions that had would definitely be classified as a strong response to the question. I think the question we have here is pretty straightforward. It's pretty straightforward, and I think it's even more straightforward than the one that we discussed earlier on. Yes, the question is in two parts, as it were. There's no doubt it's about implied terms, and as Abena and other contributors indicated, you need to explain, or you need to clarify, explicate what I mean by implied terms. And having done that, you need to let us know the justification for implying terms. What is the justification for implying terms? Now, the question has suggested a justification for implying terms, and it's an invitation for us to actually, Olivia, do you still have your hand up? Or just by, Olivia, do you still have your hand up? Olivia, do you still have your hands up, or is by mistake? Okay, she's not hearing me, all right. I think by mistake. Okay, so the question has told us, or has suggested, a justification for implying term. And that justification from the question is reasonable, giving effect to reasonable expectation of the parties. So first and foremost, do we agree that that is the justification for implying terms? And I think that aspect needs to be discussed. And I think some of the contributors made attempt to discuss that. Of course, if with respect to terms implied by statute, that is what one can argue may not necessarily be an attempt to give effect to reasonable expectation of the parties, but sometimes to also to protect maybe some weaker parties in certain type of transaction. But when it comes to the terms implied by court, right? Terms implied by court or terms implied by custom. For those ones, you can easily argue that yes, they are done with the aim of giving effect to reasonable expectation of the parties. The unexpressed intention of the party can be inferred from their expressed intention and all that. So that one is fine. And then the third aspect, the instantiation of items, which was done beautifully by some of the contributors. Yeah, so once you are able to do that, I think that we need to be able to arrive at a conclusion as whether all in all you subscribe to the view that terms are implied in order to give reasonable expectation, in order to effectuate or realize the reasonable expectation of the party. And once you do that, you have done justice to the question. Now, because time is gone, let's move on quickly to the problem-based question that okay, so let's look at the problem-based question. Sorry, you cannot see me for some good reasons, but I'm here. So don't just be looking for my video to know whether I'm around. Yeah, so let's say the problem-based question. The problem-based question, Martin, a lecturer at the business school, regularly used a Violet Limited for his drying cleaning. On one occasion, he took a suit worth £850 in for cleaning. He was given a ticket in exchange of the silk shirt. A small faded notice on the wall of the shop stated, quote, "We can only return customers' garments upon presentation of the appropriate ticket. Please see reverse of ticket for conditions." On the back of the ticket, which Martin did not read, was printed, "Attention is drawn to the following condition. In the event of any damage whatsoever caused to customers' garments, any liability is restricted to the replacement cost of the garment." When Martin went back to collect his suit, it was handed to him, but he did not bother to examine it until that evening. That evening, he discovered that suit was badly damaged. He immediately telephoned the shop to complain. The manager was not there, but the assistant told him of the conditions printed on the ticket. He has since ordered another suit from his tailor for 850 Ghana cedis. However, while the suit is being made about 6 weeks, Martin has a number of engagements to provide management training sessions to corporate clients, for which he will receive 1,000 Ghana cedis per half-day session. It is absolutely necessary for him to wear a smart business suit for this. Otherwise, corporate clients will not take him seriously and he will certainly lose future valuable work. The ruined suit is Martin's only appropriate outfit. The rest of his wardrobe consists of trendy and casual designer clothes, one very battered corduroy jacket. In order to dress appropriately for the rainy season, he buys a ready-made suit for 400 Ghana cedis. Advise Martin. Yeah, this is a very interesting scenario, and we are supposed to advise Martin. So, somebody said I should type out the points I did for the first question. Oh, I thought this was a pretty straightforward one. You still want me to do it? Okay, let me do it. Yeah, so I think the why, let me see if you can get the question. Yes, can you read the question? Those who want me to type out the points, if I'm to do it now, the screen will move and they cannot read the problem. So maybe, let me see. And I don't know that I said for it was that one. Yeah, so, I wish there's a way that, okay, let me copy it and then probably push it somewhere so that while you are reading this, I could, yeah, so let's see. Maybe you can be reading the problem while I put that there for those who have requested. Okay, so still if I'm typing it will go. So just reduce the font size. I wonder if you can read. So you just manage when I finish. So be thinking about the Martin story, why I captured this for you requested for the points for the second question we discussed. Okay, so in response to those who requested that I put down the points, and in a sense, these were the points that we discussed with respect to the question on the essay question that we look at, the implied terms. So we said explain or define implied terms as opposed to express terms, and then the second one is the justification or rationale for implying terms. And the question we need to be discussing, is it only to give effect to reasonable expectation of the parties? I said that in the case of terms implied by cause in custom, that is largely true. But in the case of terms implied by statute, not always. Sometimes the object is to protect weaker parties. And then I said that the last stage of the question is the instances of implied terms. So by custom, we discuss as we'll be seeing it by statute and then by courts. And so that is that. Now let's come back to the question we have now, the problem-based question. So I'm sure now you have you've done some thinking around the problem-based question, so we can discuss it. Okay, so for the problem-based question, as I always keep telling you that you need to follow the hierarchy. Identify the area of law, you raise issues, you take the issues one after the other, you state the principles, you do the analysis, you draw your conclusion, and repeat that for all the issues until you have exhausted them. So let me look at what you'll be able to do. So we are going to start. So we are starting area of law. Anybody who will tell us the area of law? Who will tell us the area of law? Anybody? Oh, good. You have a number. Okay, Nana Doma first. Nana Doma first. Followed by, yes. Nana Doma, what is the area of law? Nana Doma, what is the area of law? Okay. Yeah, Nana Doma, what is the area of law? You can unmute yourself. Yes. Please, we are behind.
Hello, Prof.
Yes.
Hello.
Yes, please go ahead.
Hello, Prof. Yes, the area of law is law of contract. Is contract.
Good.
Then I may proceed to put in bracket terms of contract.
Okay. Okay. All right. Good. Yeah. Okay. So that is consistent with what other people have put there. Yeah, so I like the idea of you adding the area of contract in our previous session that because of the nature of exams that you're doing about 5 or 6 subject areas. And when they give you a problem-based question, they may not, for example, say that what arise from law of contract or whatever. They will just say advise the party. So it will be useful if you could also zero in the particular subject area before you come to the broad topic under which the problem falls. So that is good. Yeah, so law of contract, terms of contract, especially terms of contract. What else? It's only terms of contract. Don't you see other areas of contracts? Okay, with specific reference to exclusion or exemption. What else? Yes, remedies for breach of contract. Yeah, that is true. Good. Okay, so now we have the areas now. Can we get the issues raised? What issues? I've told you that issues is better to always start from one sentence after the other. So Martin, a lecturer at News Business, yes. You can try your hands at the issues. So try your hands at the issues in the chat and let me see. Try your hands on the issues. I'm giving you 1 minute to do that, and then we will come back together. Okay. You're not writing your issues. I said you should try your hands in the chat. Hey, what issues arise? Okay, you want to try. Okay, so you want to speak. Okay, Dinah Boama. Dinah after Dinah, Gabriel the graft. Yeah, what issues arise from the problem? We have to hurry up. We are running behind time.
Okay, so my issue will be related to whether or not the notice, whether or not we can only return customers' garments upon presentation of the appropriate ticket. Please see reverse of ticket for condition is an appropriate notice given to Martin.
Okay. All right. So let me say what you said again.
So whether or not the notice given, whether or not we can only return customers' garments. I think the screen is offset.
Okay, you need to see the screen. Okay. Yeah, okay, it's back. Let me reduce the size so that we can see at a go. Reduce the font. Okay, so I think 12 so that you can see. You can see. Good. You can see it now. Yep. Dinah, are you there? What's here? Okay, who else? Gabriel. Gabriel the graft. Gabriel, you have the floor, yes.
Hello, sir.
Yes, after Gabriel, then Ibrahim, Halidu, and then we come to Olivia. Yes.
Hello, sir.
Yes, Gabriel, go ahead.
Yeah, my issue is whether or not the notice given by your birth limited push them away from liability, or does not make them liable for the defect on the suit.
Okay. Okay, that is okay, that is fine. All right, let's take another formulation. Yes, Ibrahim Halidu.
Yes, sir. Can you hear me?
Yes.
Yes. So let me try. Whether or not Martin will be bound by the ticket he received from Valet Limited without reading its content.
All the things you have said are interesting, but you need to formulate the issue in such a way that it directs your mind on even the principles which need to be stated and then applied and all that. That is one thing that we need to pay attention to. Let's take one more. Okay, you have some few more people here. Okay, Olivia. Olivia, are you there? You keep putting up your hand. Please, you don't talk. Is it by accident? You put up your hand. Okay. Titi. 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 It's, okay, let me bring some other people. Let's look at the chat. Although not the close, it don't take it. Okay. Yeah, okay, let me comment on some of them. Since people are not talking. So those who have the chat one, I'm commenting on those in the chat. Oh, is that muted? You're muted. Oh. Unmute yourself. Unmute yourself, please. I've released you. I think he doesn't know how to do it. Okay. Just click your mic and then you're muted. Okay. Okay, so then time is being so yeah, so let's go to use the chat. They use the chat. Yeah, so someone has said the main issues person didn't specify whether or not Velvet Limited can rely on the exclusion clause to observe itself from liability in regards to the 400 suit matter. Okay, I mean, Adwa, I like that. I like Adwa, I like that. I mean, that is a good way of formulating issue. One thing I like about Adwa, what you have done is that you have weaved the facts and the key principle area together. There's no doubt we are talking about exclusion process or process. So whether or not the verbal limiter can allow in the exclusion, but if you say the exclusion clauses to absorb itself from that one too is a little bit too broad. If you could, Ajua, if you, for example, because let's say we see two things, right? We see a small faded notice on the wall of the shop. And then you also see on the back of the ticket, if Martin did not read. Or you want us to read together? Yeah, so probably that is the only problem I have with otherwise I like how let's look at David. Whether or not the express you have ever limited in the contract with Martins, the exemption or restricted only to placement cost only. Okay, that is fine, David, but they said that is ready. I mean, you have the ideas, certainly. Let's see if there are others. Richard, whether or not the exclusion clauses to absorb your exclusion, if you say the exclusion clauses, what are they? You pick something from the facts, right? Instead of saying the exclusion clauses, you say that whether or not the notice on the wall, right? I'll prepare whether or not the notice on the wall, for example, constitute a valid exclusion clause or constitute a valid, or whether or not the statement on the ticket, whether or not like the statement on the ticket constitute a valid limitation clause, right? Constitute a valid. Don't forget that what is here is taking your mind to limitation clause, not exclusion clause, because that intention is drawn to the following condition. In the event of any damage that's ever caused to Catholic government, any liability is restricted to replacement cost of the government. So this is limitation clause. This is not exclusion clause, assumption clause. Because assumption clause or exclusion clause is a total exclusion, total avoidance of liability. But here, it is not total avoidance of liability. It is only saying that yes, if you are liable at all, our liability is up to the replacement cost and no more. So that is, so far, what you have done, I haven't seen that coming out. Of course, I appreciate the fact that oftentimes we use exclusion clause and a limitation clause interchangeably. So I should like to presume that maybe when you are putting the principle in the discussion, be mindful of that distinction. And that is why you're probably not bothered with the word because you are just assuming so that is, and so long as it is in your mind that you'll be appreciating that distinction, then that is fine. I think I've seen another person, whether or not the clause containing the ticket applied to Martin. That one is too general. Whether or not the inscription of the ticket exonerate velvet from any liabilities toward Martin. Okay, that is fine. So let's come back together. So if you read the scenario, you notice there's no doubt that the main area of law, the law of contract, especially exclusion and limitation clause on the terms, as well as remedies for breach of contract, as some of you have rightly stated. So the main issue here, you see from reading the story, you read the first statement, certainly there's nothing. On one occasion, he took a suit with this, was given a ticket necessary for the silk shirt, and then a small faded notice on the wall. The shop stated this. And then please see reverse of ticket for conditions. on the back of the ticket, which he did not read, was printed. So these were certainly, so the words on the notice on the wall, whether the notice on the wall constitutes a valid limitation clause. And of course, the notice on the wall is more or less, it goes together with the ticket as well. Because that please see reverse condition. Or you could break it down, whether the notice of the wall is a valid exclusion stroke limitation clause. Do the same thing for the ticket. But I like how Ajua put it, trying to the recovery of the particular money that Martin is thinking of to the West, which the company may want to really take advantage of. So you have that. The most important thing is you getting the substance. In terms of the wording, because we're over 200, people will use different words to formulate the issues. There's no problem about that. What is important is the substance, that you're able to appreciate that the main issues, revolve around this, words, the notice. The issues revolve around that. That is fine. Then what about when Martin went back to collect his suit, it was handed to him, but he did not bother to examine it until that event. Does that raise any issue? Not as an issue on its own directly, so we ignore that. That even discovered that the suit was badly damaged. Does that raise an issue? Of course, that is what brings up the relevance of the notice and the ticket. So as to whether Martin can sue for damages for breach of contract, because if taken like the suit there, the suit is supposed to be taken through dry cleaning process for you and not to be damaged. So he immediately telephoned the short complaint. Has it raised any issue? Not really. The manager was not there, but the assistant told him of the condition printed on the ticket. Okay, does it raise any issue? It will be taken care of when we are discussing the notice and the ticket that we have raised issue already around. He has since ordered another for £850. Does that raise any issue? Does that raise any issue? Yes, because we have an issue around the, damages for breach of contract. So here is pointing us to if there's a breach of the contract, in the sense that the thing that you took to the laundry when you needed it, it's not ready to be used. Assessment, that is a breach. Is he supposed to do any mitigation damages? Remember when we discussed when we talk about mitigation of damages. So can we be thinking along that line, that by ordering another suit, Martin is trying to mitigate his losses. However, why the suit he made about says Martin has a number of engagements to provide management training session to corporate clients, for which he receives $1,000 per half-day session. Does it raise any issue? Now that is taking us probably into the what we call like the special damages, or the second rule in Hadley and Basindel, as discussed further in the Victoria case, which we have made already. And it is absolutely necessary for him to wear suit for this. Otherwise, corporate clients will not take him seriously. Does that really mean you should know? The ring suit is Martin. Of course, that takes up the information, right? Information sharing. If you have to discuss special damages, like what information they don't make available to the other contracting party concerning your circumstances. The ring suit is Martin's own appropriate outfit. Does that raise any issue? Remember the working shaft, and then the court of the as to whether the male will have a spare shaft or not. It all depending upon the information that the millers give the career. So here, the ring suit is Martin's own appropriate outfit. Now, did Martin tell the laundry whether he did not have any suit apart from the one that he had taken there? Now, if he told them, and then he also told them that he has some other engagement and all that, he was making 1,000 Ghana cedis per half this, would that have made any difference in terms of how much he could have actually recovered by way of damages? So these are the kind of issues which actually, in order to address appropriately for the training session, advice ready for 400 Ghana cedis. I've seen a number of hands up, so let me release it before I continue with the response to the question. Prince, Petia, you want to speak? Or just by mistake? Yeah. Okay, since I'm sure I'm not clear. You want to speak?
Yes, Doc. I wanted to find out, I am going back to the issues being raised. I know that a court will only enforce an exclusion clause where it is in a standard form of contract. So therefore, I want to find out, when you look at the factors a court will consider in enforcing an exclusion clause, it says that the clause must be well noticed. But then I want to find out, so then can we raise an issue whether or not the ticket in exchange for the silk shirts constitutes a valid contractual document?
Okay, that is another way of putting the other issue that raised, or that is a sub-issue, because you are told that where the exemption clause is in writing. I think my line went off, but I am back. My line went off briefly. Yeah, so Akuya, yes, you can raise an issue around that, so long as you are not indulging in repetition, especially if you've not raised like a general issue as to whether the words on the back of the ticket constitute exclusion clause or clause. If you haven't done that, then you can do what you have suggested here. That is fine. I see some hands. Are they up or the old hands? Yeah. Whose hand is up? And you want to say something? Okay, so let's assume that you have the issues that we have raised. So what we have said, you have to take them one after the other. So let me take one of your form. As we discussed that, I think I'll go back to address issue. I think it's gone. So many have come. Okay, okay, so Abigail. Okay, a lot of you have put a lot of things in the chat which I won't say. Sorry. Abinawa, why do you want to talk about standard terms contracts? Why? Okay, Abinawa, whether or not Martin is bound by the clause at the back of the ticket, whether or not the one can be made to refund Martin the 400 he spent in the new suit. Whether or not the notice has contained the ticket considered an appropriate notice. Okay. Let's please if you are the noise
So nobody is listening.
will come with it. Okay, so let's take I don't know, rely on exclusion clauses to absolve itself from liability in regards to 400. Okay, so let's say that as the issue that we are discussing, you have to tell us all the relevant principles regarding exclusion. And what to do, you have to let us know that this depends largely on my line, but I am back. Yeah, so I was saying that you have to take the issue and make them in a topic form. And I was just trying to recap what we've discussed. So all the things that we've discussed regarding exclusion clauses, you will remember that the validity of exclusion or limitation clause depends upon whether it forms part of the terms of the contract. And how do we do that? It depends upon whether it requires the signature of the parties or doesn't require signature of the parties. So where it requires signature of the parties, then once you have signed, generally you are bound by it, except where the exceptions apply. On the other hand, where it doesn't require signature, but it is in writing, all that is required of you is that reasonable notice should be given you regarding the existence of the exclusion or limitation clause before or at the time of making the contract. You know the cases, Ole, Marlborough, Thompson, and Midland Railways and all that. So you go through all those cases. Then when you